All right, guys, we're going to go ahead and get started. For those that have been to these, welcome back. For those that have not been before, welcome to the first one. I always tell people that we're kind of going to be looking at the back of the room as well, because we actually have, we send this out to our 23 chambers, and a lot of them host their own simulcast. So we have people watching online as well. So when questions are asked, we will repeat the question just so our end users out there can watch as well. The simulcast option is always available to you as well. If you saw the email come out for me this morning, sometimes people cannot make it all the way downtown or prefer just to jump on and watch at their desk too. So always an option for you as well. So today we're going to be talking about top 5 things to know when hiring. This kind of builds on to our last session we had a couple months ago on employment law. And then also coming up in January, we have, once you get these people hired, if we have discipline issues or we need to terminate, we have another session coming up on that as well. So today we have Kelsey Crosse and Maggie Hanson of Davis Brown here today with us. They both practice in the area of business law. So I'm going to hand it off to them. They're going to duo the presentation here. If you have questions, feel free to raise your hand. Again, they'll need to repeat the question, but we'll get going. We are missing a handful of people that might sneak in the back, so please just ignore them as they sneak in. All right, we'll get going. Thanks, ladies, for being here today.
Thank you. Okay, well, welcome, everybody. We are so honored to be here. Thanks for having us today. We're going to be giving a presentation on turning up top talent. My name is Maggie Hanson, as has already been mentioned, and this is Kelsey Crosse. We're both attorneys at the Davis Brown Law Firm here in Des Moines, downtown, just a short walk away from here. And we both practice in the area of employment law. We do a lot of employment law, represent a wide variety of employers, from startups to well-established companies, in a variety of forums, federal court, state court, administrative forums. And we give presentations like these a lot. We advise employers on issues of hiring, firing, discipline. We talk about drug testing. We talk about almost anything you could encounter in the world of employment. But today we're going to focus on hiring. We're going to talk a little bit about how we get to our top talent. So I'll turn it over to Kelsey briefly.
Yes, so to add to what Maggie shared with you all, we both advise employers on how to avoid getting sued. And then if they do get sued and there's a lawsuit, we also defend them. So some of our advice that we share with you today is with both parts of that, because we both are now in our 5th year of practicing. So in just that short amount of time, we've witnessed and observed a lot of things that employers do well and a lot of areas where they can improve upon. So we will incorporate some of those examples into our presentation. Now, hiring is one of the most difficult parts of management because it's natural to want to know as much as you can about an individual you are hiring. But unfortunately, there are laws that pertain to certain protected characteristics that may make some of the information that you might want to know, it may expose you to liability if you find out about that protected characteristics and that information. So this includes things like race, gender, color, creed, national origin, religion, gender identity, sexual orientation, etc. So we will talk about a variety of protected characteristics and how those implicate the hiring process. With that being said, I do want to give a disclaimer at the very beginning of this. In the world of employment law, it gets complicated. And what the advice we share with you today, one single fact can change our recommendation and our analysis. So please keep that in mind. Of course, there's no substitute for independent legal advice. We will point out later on, Maggie will talk about the Americans with Disabilities Act and accommodations in that regard. And that is one area where it gets to be very complicated. So we would encourage you, when there's accommodation issues, to work with an attorney to sort through some of that.
So we'll start off, and we're going to cover a variety of topics today. We have kind of our list of our top 5 here. Employers today, face a wide variety of challenges when you're trying to find talent. There's a shortage of talent. We have trouble finding good people to work in our jobs. So we're going to talk about how you find talent in the right way. How do you do it without getting yourself into a situation where you're put at risk as the employer, where you could possibly be sued? How do you do it without risking those types of things? So we'll talk a little bit about job descriptions, applications, background checks, the interviewing process, and then the contingent offer. And then we'll throw in a little bit of drug testing at the end just to round out the whole presentation. So I'll let Kelsey get started.
All right, so the first tip for trying to tackle the hiring process is to begin thinking about the job description. What job do you need filled? What requirements of that position are important? Let's think about the work that needs to be done, how it needs to be done, the frequency of the work that needs to be done, and the purpose of the work. Now, in the job description, not only should you list the name of the position, but also think about whether you should include the classification of the position. Is it an exempt employee that will fill this position or a non-exempt employee? And so for those of you that may have less experience with the Fair Labor Standards Act, that relates to, is this a position where overtime may be available? And that person will need to be paid at 1.5 times their hourly rate? Or is it an exempt position where there's certain exceptions to the need to pay overtime? If there are exceptions where the overtime is not needed, that would also influence what you include in your job description. Additionally, think about, are there certain competencies that are required for the position? Is there bending, lifting, physical requirements that are very important to this position? And think not only about, is that required, but how frequently is that required? There was a case that I was involved in that went to trial early on in my career, and the job description was a main exhibit for us because it talked about the essential functions of the job, which should also be included on your job description, and it talked about the necessity for the frequency of being able to lift certain pounds. And so that was very important. Now, your job description is important not only to help you identify how to recruit talent, what position do you need filled, but it also can be used as a tool to help you evaluate the employee. You can use that for evaluations and for discipline later down the road. And additionally, it's very important for a couple of reasons. First of all, it may be an issue if there is a discussion about whether the employer should provide reasonable accommodations and whether a reasonable accommodation is available. For example, when you identify what is essential to the position, perhaps it's a safety-sensitive position. So because of that, if the individual is consuming certain medications that may alter his or her abilities, perhaps there is an accommodation available for that position because of the job requirements. Maybe it's driving a car, for example. Also, when you think about the essential functions of the job, it's what's most critical to the job. And it's possible that maybe an individual will say, I wasn't hired because of a certain protected characteristic. But if we can point to they weren't qualified because here's what was required on this job description, that will help us demonstrate that they weren't hired and it had nothing to do with their protected characteristic. Sometimes employers include on the job description what is the minimum amount of competency required or a minimum amount of education, which is fine. Sometimes employers also do what is a preference or what is required for the position. That's also fine. My only caveat is just like your employee handbooks, your job descriptions likely evolve with time. So you really should docket an annual reminder so that you go back and you look at that job description because it's possible maybe an employee their job has morphed and they're doing an entirely different job. And really if what the essential functions of their previous job are, if 2 years later it's different, that won't help us if there becomes an accommodation question or a disability-related inquiry in the future.
So I have a question about that.
Sure.
If you've listed minimum education and that...
I'll repeat the question.
You've listed minimum education, the job is morphed. Can you alter that job description while the person is in the position?
So the question is, and correct me if I'm repeating it wrong, but what if the job has evolved and the required education for the job has also evolved? Can you alter the job description? So I want to answer that question in a couple of ways. First of all, the main point of our presentation, the big takeaway, is think about protected characteristics and think about your hiring practices and think about the steps you can take to demonstrate that you are hiring You're making your hiring decisions based on whether or not somebody is qualified, and not because of the protected characteristics. So when we think about, what education is important to a specific job, think about why is that important? Because for some jobs, maybe a janitor cleaning the hallways, it doesn't matter if they went to college, it doesn't matter if they have a master's or a PhD. So later on in the presentation, I'm going to explain the differing types of discrimination claims and how one of the claims can be tied to directly discriminating against somebody because of a protected characteristic. You're not hiring them because of their race, because of their religion, etc. But another type of discrimination claim is called a disparate impact claim. So it means you're treating them the same, but there's a different impact, a disparate impact. So for example, in the 1960s, when the civil rights laws went in place, some employers continued to have practices that weren't really tied to a business need or a business justification. So there were claims in that way. So for example, some police officers, employers had requirements that required them to take certain academic tests, and it weren't really tied to their ability to do those specific jobs. So what ended up happening is there were claims saying you treated everyone the same, but the impact affected a certain protected characteristic or a certain minority group. So if you have, a neutral policy applied to everyone, but the impact on certain protected characteristics is different, that's fine if you truly have a business justification or a business reason for doing that. But if you can't really tie it to a business justification or need, then we open the door to that risk of that type of claim. So with your job descriptions, just like your employee handbooks, we highly recommend that you include the date that it was created and the date of revisions. So that way, if the job has changed, maybe you don't need that prior position anymore. And so you're, re-interviewing the current employee to fulfill a different position. You can change your job descriptions. Again, we just need to demonstrate that the reason you are doing that is because of a legitimate business need and it's not because of a protected characteristic. Yes?
But the language, other duties as required, which can be quite nebulous.
So in the world of employment law, Maggie and I and several other employment attorneys at our firms, we don't always agree on the answers to questions like that. I mean, it can be a little bit personal preference. Sometimes I like that wiggle room because then I can argue what the other stuff is, which is fine. But the most important thing is if it's truly an essential function of the job, and you, employer, don't list that as an essential function, when there's a lawsuit claiming I should get an accommodation and it's not really an essential function, then that becomes an issue. Because if it was really important, the employer likely would have included it. All right, so my other takeaway for the job description is similar to the application. One way to protect yourself is to have what we call an EEO policy or statement or disclosure on your job description and on your application, and it identifies that you are an equal opportunity employer, and so you don't discriminate on the basis of protected characteristics under state, federal, and local law. And so we just kind of put that on those materials, and again, we can point to that later on if an issue arises. All right, step number 2 in the hiring process. What should be on the application? Well, first of all, should you use an application? Why? Some employers prefer to use solely resumes, which is fine, but the nice thing about applications is it will consolidate all of the information about applicants, and it's in a consistent manner. So you can easily compare individuals, and you can control the information that's provided. In a resume, the individual gets to self-select what information they share. Now, to go along with the big theme here, what should be on the application? Your application does not need to ask questions about their protected characteristics, their race, gender, religion, national origin, color, creed, etc. Why? Because those things are not relevant to whether they are qualified to perform your specific job. So let's talk about some of the other protected characteristics that sometimes employers find to be a little bit trickier. The first one is age. So under the federal law, age is a protected characteristic for those individuals that are 40 and over. And under Iowa law, age is also a protected characteristic, but it doesn't have that 40-year cap attached to it. So you can ask if somebody has the minimum age requirement necessary to perform your job. If your job involves serving alcohol, for example, and the employee needs to be a certain age, you could ask that. But otherwise, if your job requirements for the position don't relate to somebody's age, don't ask that because you don't need to know it. If you are getting at somebody's experience, experience is directly related to somebody's qualifications for the job. So you can certainly ask about somebody's experience. Now the problem is when employers sometimes start making assumptions about individuals. So for example, neither my mom or dad is an attorney, but let's say that they had a second career in life, and so they recently went to law school and they're interviewing for a position. It's possible that I may have more experience practicing law than they do, but because of their age and their appearance, an employer might assume something. So again, let's not focus on age, because that can be misleading. Let's focus on the individual's experience. All right, the next protected characteristic is marital status, the number of children you have. Are you pregnant? Do you want to have children? Again, not related to whether the individual can do the job. And in Iowa, we have the Iowa Nice, where it's natural to kind of have conversations where individuals disclose those sort of things. If somebody wants to volunteer that, that's fine, but you as the employer should not be asking those questions on the application. That is related to one's gender identity, sexual orientation, gender, and pregnancy also can be a protected characteristic. All right, regarding citizenship. Citizenship is related to the protected characteristic national origin. So you don't need to ask somebody, where were you born? Because that, again, relates to national origin. Rather, you can better ask that question, are you legally authorized to work in the United States? Because it's possible they're a citizen here or they have a green card, and either way, we shouldn't discriminate about whatever answer they give so long as they are legally authorized to work here. Okay, what about physical descriptions? Asking about somebody's height, weight, eye color, etc. Again, those relate to potentially race, color, and those sorts of protected characteristics. They can also relate to whether somebody has a disability, given their size or their height, and their weight could also relate to if they have a disability. And so you likely don't need to ask those questions. Instead, you could ask if the applicant can lift a certain weight essential to do the job with or without a reasonable accommodation. Now the buzzwords are with or without a reasonable accommodation, because it's possible somebody may need assistance to perform certain job functions, but they still, pursuant to state and federal law, may be entitled to an accommodation. Along the same lines of disability inquiries, you also shouldn't be asking on an application about one's workers' compensation history, how many sick days they took at their previous job, how many days they missed at their previous job, and those sorts of inquiries. Because it's possible they did have workers' compensation leave, or ADA disability leave, or FMLA leave. And again, all of those are protected characteristics that really should not pertain to you as an employer evaluating if the individual can do the specific job. Last, I want to emphasize, we talked about education and competencies and what licenses do you have for the position. You can certainly ask about those. Just keep in mind when you ask about what other memberships do you have or how else are you involved in the community, you may get answers that do not relate to your job at all that could also reveal protected characteristics. So we talked a lot about what protected characteristics are. There's also an associational component to that. So it's possible, for example, that I could be very actively involved in the African American community and memberships associated with that. And so even though I'm Caucasian, I might have an associational discrimination claim. And so we also have to be mindful of when you are asking about, people's community involvement, you may also elicit protected characteristics. Okay, so I've already explained that disparate treatment, treating somebody differently, and then disparate impact, treating somebody the same but having a different impact to certain minorities or certain individuals with protected characteristics. This ban the box is a federal movement where in 19 states and approximately 100 cities, there's been an effort to limit or narrow the use of an individual's criminal history by an employer. And the reason is because sometimes employers were using one's criminal history, and they were using that to make a hiring decision, and the criminal history was so long ago, or it wasn't related to the job, that the EEOC, the Equal Employment Opportunity Commission, that enforces a lot of the employment laws, thought it could result in a discriminatory impact. You're treating everyone the same, but you're negatively impacting a certain group with protected characteristics. So Iowa has not followed this trend of ban the box. So in Iowa, you still can ask about one's criminal history. But according to the EEOC, one way to try to, again, tie it to that business necessity is to look at the nature of the job. Of course, if the individual you are hiring is going to have access to valuable resources and money and financials, you might very well want to know one's criminal history. But again, if we use the janitor cleaning the hallways, for example, it might not be as relevant. So look at the nature of the job, the criminal offense of the individual, and the time. Like, how long ago was that? If it was 20 years ago, it might be less relevant. With that being said, Iowa does not limit your ability to ask about one's criminal history. And like I said earlier, Maggie and I both do litigation work. So when I sometimes have a plaintiff that is a convicted felon, I like to look back at their employment application and see if they were truthful in that application, if they disclosed it. Because if they didn't, then I can use that to diminish their credibility. The other thing to keep in mind is that criminal cases and really all lawsuits can take a couple of years, sometimes even a few years if there are rigorous legal issues involved. So it's possible somebody's been convicted, but they're in the process of appealing it. So keep in mind that it may, if that is something that concerns you, it may be worthwhile to have a conversation to verify that the information you are relying on is accurate, and also refrain from asking about if somebody's been arrested, because it's possible somebody was arrested and they did nothing wrong. And so be mindful of that. So in Iowa, you can ask the question, do you have a record of founded child or dependent adult abuse, or have you ever been convicted of a crime in this state or any other state? So you can ask that question, but be mindful of if you hear about this ban the box movement that is taking place, because the limitations of the ability to make that inquiry may change. All right, so we talked a lot about what you can't ask or what you shouldn't ask. Let's bring it back to what you can. Certainly you can ask about, who are your references? Could you provide me with some names of individuals that I could contact to have a conversation about your ability to do this job? Certainly you can ask for the individual's contact information, all about their job history and their education history. Those are all questions that you can certainly ask to evaluate if the individual is capable of performing your job. All right, so in addition to protected characteristics, there's another legal claim that individuals can make, and it's called a negligent hiring claim. So for example, let's say you didn't go through the application process and you hired somebody that you kind of knew, and later on down the road, something happens, and you discover that the individual is a registered sex offender. And maybe the employment position had access to children or access to people's rooms where they would be sleeping overnight, etc. There is another claim that maybe an individual that is not even one of your employees could bring, and that's called negligent hiring. So you do want to do some level of due diligence to make sure that you are hiring trustworthy people. One way that employers go about this is they use a third-party company to help them conduct a background check. Maybe if it's a driving position, they want to obtain one's motor vehicle history record to make sure they are a safe driver, or somebody's criminal record, or if it's a bank and it involves finances, they may want to obtain one's credit history. So whenever you are using a third-party company, it's sometimes called a consumer reporting company, you need to follow certain steps. So what you first need to do is you need to get a consent from your applicant that you can use that consumer reporting, that third-party company, to help you with the background check. Now, this pertains to the federal law called the Fair Credit Reporting Act. It's actually a really easy law to follow, but it's very specific. You kind of have to dot your I's and cross your T's, so to speak. So when you obtain this consent from the employee, you need to make sure that it is not in your employment application. It needs to be a stand-apart document, and the Consumer Financial Protection Bureau has said that that's important so that employees aren't just signing things not knowing what they are signing. So that's step number one. If the individual says, I don't want to sign that, I don't want you to do a background check, you don't have to hire them. That's fine. But you cannot go out and use that third-party company to conduct that background check without getting that form. Otherwise, you risk violating this federal law. Step two, let's say you get information back in this consumer report and you don't like it. It makes you think, I don't want to hire this individual, this isn't good. What do? You have to give them another notice. You have to give them the consumer report. You have to give them a handout called a summary of your rights under the Fair Credit Reporting Act. And you need to identify what was in the consumer report, and then certain other requirements, which include giving the individual a reasonable amount of time to let you know if that's accurate or to explain anything. Because what happens is sometimes these consumer reporting companies, sometimes they get it wrong. When there's an individual that has a name and it's Tom Smith, and there's a lot of Tom Smiths, or the date of a conviction is wrong by 20 years, and that could have a significant impact on your decision whether to hire the individual. So if you use that third-party company, you also have to give them that second notice and wait a reasonable amount of time. Then, after you decide, maybe they never respond and you give them 10 days, and you decide I'm not going to hire the person, you have to give them yet another notice of your decision not to hire them based on the information in the consumer report. So it's actually really easy to follow, but it does involve certain requirements at each step, so keep that in mind.
Okay, so we'll talk just a little bit about reference checks in the sense that you are asking for references from someone and you just want to give this person a call, perhaps. Perhaps it's a prior employer, perhaps it's someone else that this person, your applicant, is familiar with in the community, and you want to give this person a call and figure out what that entails. So first of all, at the time of the interview, you want to be explaining the process to this applicant. What are you going to do as far as background checks? And if it is going to involve some of the items Kelsey's been talking about, fair credit checks, things like that, you're going to want to explain that process too. If you're obtaining some more information on the person's background, you're just going to want to get into everything that you're going to be discovering about that person and make sure you explain it thoroughly. If we're talking about calling someone's references, be sensitive to contacting a current employer. You know, in this day and age, people are switching jobs a lot, and they may be applying for jobs at a time when they're still currently employed by someone. So be sensitive to that. That's just kind of a practice tip. There's no legal reason for doing that, but just be sensitive about that. And additionally, be mindful if there are gaps in their references. That's for your own protection. This could raise a huge red flag if someone has a gap in their references, whether it's time or omission of a significant employer that they were previously employed with. So if they had 3 prior employers and they don't list the employer who they were employed with for 10 years. That might give you reason to pause and think about what's going on here. Additionally, I say up here, obtain a release. And what I mean for that is not if you're going to just call someone and see, call a prior employer, call someone's reference. You don't have to obtain a release and consent for that. But if you are going to request employment records from a prior employer, you do need to get that consent and release from that employee, that applicant who's applying with you, because that is protected information that can't just be released by anyone without some sort of release and consent by that particular individual. And then if you are obtaining those type of records, be mindful of common law privacy concerns. If you're going to get someone's prior employee file, are you getting medical information? Are you getting other private information that is contained in that file? So don't be sharing that. Be keeping it confidential in accordance with your confidentiality policies, and just be mindful of those things. And then finally, make sure you're only obtaining and using accurate, current, and relevant information. This goes back to a lot of the things that Kelsey's just discussed with you. We're talking about what's relevant for someone to be able to perform the job that we have open. It's not their race, their creed, their gender. It's bona fide occupational qualities. What does it take to perform the job that you have open? So make sure those are the things you're considering. And then it's best, if you're doing these third-party reference checks, to develop a policy about how you're going to do these things. Determine those policies before you're doing these interviews and before you start doing these reference checks. And it doesn't have to be any sort of specific formula, any specific equation. It can be just kind of a loose policy about the fact that you do reference checks and maybe some guidance for employees, supervisors who are perhaps doing these reference checks, and what they need to be considered or need to be considering. You might have some more specific rules if it comes to items like criminal convictions, things like that. You might have some more specific directives for your employees or for yourself if you're doing the reference checks. But again, it doesn't need to be a specific formula. And then remember, on the flip side, if you are providing a reference for someone, you've gotten a call, say, from a prior employee or from a company at which a prior employee is applying, you get that call, what kind of information can you provide? Just keep in mind that you should be providing information related to those job qualities or those job requirements for the new job that they're applying for. You don't need to be reporting things about protected characteristics. You don't need to be reporting how many sick days this person took while they were employed with you. You don't need to be reporting about their race, their gender, their religion, things like that. And under the Iowa Code, you are protected for providing good faith, reasonable information. So as long as you're doing that, you shouldn't be picking up any sort of defamation claim or things like that. That can happen to employers if they provide too much information. And then briefly, I want to talk about background checks in the ADA. The overarching theme to remember is that background checks have to comply with the ADA. For those of, most of you know, the ADA is the Americans with Disabilities Act, and this protects people from discrimination based on a disability. So we'll talk about this in greater detail a little bit later, but employers can't ask disability-related questions before a conditional job offer has been made. This is important to remember. So this applies to the background check phase, this applies to the application phase, it applies to the interview phase. So just keep that in mind. And just generally, we don't need to be asking about nature, severity of disabilities. But that's the important thing to remember. We won't get into too much detail with regard to the ADA because it is a pretty complex law. Okay, I'm going to skip a few slides because we had these a little bit out of order. But we want to talk about social media a little bit now. We all know this is a big issue in today's society. Social media is a growing advent. People are using social media for all types of things, to report, to market themselves, to report work-related things, to socialize with other people, to post opinions, to post articles. There's just a variety of things that it's being used for. So back in 2013, SHRM did a study about who was using social media for employee recruitment. And what they came up with was that about 77% of these responding companies to this survey were using social media for employee recruitment. And undoubtedly, since that time, we're in 2017 now, that number has probably gone up with the advent of social media. We're also talking about 22% of HR professionals who use social media to research those job candidates as well. And importantly, this is kind of funny that it has declined from 2008, when only about 34% of people were using social media, and I should say 34% of responding companies were using social media for this employee recruitment. And why was that happening? Well, people, as social media came into being and became popularized, people were scared. How do we use it, and how do we use it correctly? Are we going to get sued for looking at this? This is information we previously didn't have about employees. We couldn't initially look them up on Facebook. We couldn't look them up on Instagram. Now we can do that. So we saw a decline, but now we're again seeing kind of an increase from 2013 as people are figuring it out. And Kelsey will discuss this a little bit later, but we have 18 states that ban forced access to social media. Iowa's not one of them. We'll talk about this a little bit later, but you can't really force someone to give you access to their social media pages. And Kelsey will get into how you can do this appropriately and what you can consider when you're looking at someone's social media. Again, some other numbers. Everybody's using social media. We have 1.87 billion users on Facebook. It's just good for us to be aware of how many people are using Facebook, not only for purposes of employee recruitment, but the people we are recruiting. They're all using it too. So it can be a double-edged sword. We can use it for good, but it can also be misused. So important things to remember.
All right, so can an employer legally look at an applicant's social media profile, let's use Facebook, to evaluate the individual? Yes, you can do that, but as Maggie alluded to, it's not without risk. So for example, let's use a lighthearted example. Let's pretend that we are evaluating Ellen DeGeneres as an employee at your company, and you decide to go to Ellen's Facebook profile. Let's pretend her Facebook profile picture is what's portrayed here, an image of her with Portia. Well, you just discovered through one profile picture that she's female. You discovered her sexual orientation, arguably her gender identity. So you discovered protected characteristics that aren't, necessary for you to evaluate if Ellen can perform the job at hand. So how do we address this? I'll give you the answer, but we're going to let you think about it for a second. Maggie's going to walk through hiring not only Ellen, but let's pretend we have another applicant.
So we have this other applicant for the job, and her name is Ann Hanson. If you've remembered my last name, this is my mom. I have asked her permission to use a screenshot of her Facebook profile for these purposes, so don't have to worry about that. But we have Ann. We can see a few things from her Facebook just initially by looking at the first page. First of all, we look at her profile picture. And assuming that's her on the right in her profile picture, we can maybe assume a few things about her. First of all, we can look at her, and she's a female. Perhaps that's her husband, and I can tell you, yes, that is her husband. That's my dad in the picture with her. So she's married. We think she's married. We can also see that perhaps she's over the age of 40. And again, because it's my own mom, I can tell you she's over 40, even though she might not want me to tell you that. But she's over 40. And then we see a few other things from her Facebook profile. Some of these pictures might give us reason to believe she has a few kids. She's got a family. They might give us reason to believe some other things about her. She likes to travel. We know some other tangential things about her. But then we go to her wall, and we see perhaps a political article. So we might get a sense about her political leanings. We might get a sense about what she thinks about what's going on in government right now. What can we consider? So we get all of this information just from someone's cover page of their social media. But what can we do with it, and what should we be doing with it? So I'll let Kelsey talk about that. Oh, you'll have to flip.
So how do you go about this? How do you get the best of both worlds? How do you get the information out there on the internet and on social media about an applicant that you want to know, that would shape your analysis of whether to hire them, without getting the protected characteristic information? Well, one way you can do that is have a screening process. So the individual that will actually be making the hiring decision should be kept separate from the individual actually looking at their social media profile and account. And you could take it a step further. You could even have that be a written policy. So it's possible that the individual that looks at the individual's LinkedIn profile, Facebook, websites the person may have, they can filter out and screen out those protected characteristics so that those that are making the hiring decision were not aware of them. And we can point to that as a defense in the event somebody contends that you improperly relied on a protected characteristic. Now, I want to point out that we have been talking a lot about Facebook because that's easy when so many people use it nowadays, but it also pertains to websites. For example, there was a case that involved a professor in the University of Kentucky, and this university was evaluating whether to hire the individual, and they looked at his personal website, and as a scientist, they also, when evaluating whether they should hire him, they had discussions about his religious beliefs that were on his personal website. So he didn't get hired, and a lawsuit arose, and the university tried to not have the case go before a jury. So they did what's called a motion for summary judgment, and they said, look, court, we didn't rely on a protected characteristic, his religion. We hired somebody else because that person was more qualified. The court said there was a fact issue about whether his religious beliefs were a motivating factor in your decision to hire him, such that it became an issue that the jury should decide. It became a fact issue. And so whenever there are fact issues like that and there's arguments that can be made, it increases dramatically the settlement value of a case and your legal risk. So we want to try to minimize that by minimizing those exposures to the protected characteristics, by using that screening process so that we can fully defend your decisions.
So the next step in the process we've talked about job applications, we've talked about doing some background checks, we've talked about using social media. Now we'll talk a little bit about interviewing. So now we're bringing a person in for an interview. We've looked at their application. We've determined that at least they are qualified enough for us to bring them in for the interview process. Now we need to kind of look back. We need to look back at what did we require on the job application itself. The same sort of prohibitions should apply to your interviewing process. If you're not asking about someone's race, creed, color on the job application, as you should not be, you should also not be asking those types of questions in an interview setting. So remember, throughout the hiring process, we just need to fall back on that EEOC, those Iowa Civil Rights Act protections for people. We shouldn't be considering any of those factors at any stage of the hiring process, no matter what it is. We come to, however, those pre-employment disability-related questions again. We come back to that again. So again, at the interviewing process, this is not a proper inquiry, not proper for you to get into disability-related questions. And we'll talk on another slide. I know I keep kicking the can down the road, but I promise we'll get to it. Additionally, with background checks and criminal history, you need to be informing people, as I stated before, at the time of the interview that you're going to be looking into these types of things. And finally, if you're going to be doing any sort of pre-employment drug testing, make sure you're also informing the person at the time of the interview, and I would recommend having this in any job advertisement as well, that pre-employment drug testing will occur. But you do need to be informing them at the time of the interview that this will occur, the procedures or how it will occur, and you also need to provide them a copy of your drug testing policy. So I would have that, available on the table if you're bringing someone into the office. Have that available for their review at the time of the interview.
All right, so while you are conducting the interview, I also want you to be mindful of potential areas where an employer has an obligation under state and federal law to potentially provide a reasonable accommodation to an individual. One of those is if there's a disability. The employer may have an obligation to engage in an interactive process with the employer or applicant to see if he or she can do the job with or without a reasonable accommodation, and if they are capable of performing those essential job functions. Another area is if somebody needs an accommodation because of one's religious beliefs. So, for example, the picture in the right corner is of Samantha Eloff. She interviewed with Abercrombie & Fitch, and it was a couple of years ago, and she wasn't hired. Abercrombie had what's called a look policy. So a lot of employers have dress code and grooming policies, and Abercrombie's was called a look policy. And so they didn't let their employees wear, anything on their head, including a hijab that Miss Eloff wore when she was interviewed. Now, this case went all the way up to the United States Supreme Court and then was remanded back down. And there was an argument about notice versus knowledge. The employer was arguing she didn't ask for an accommodation, she didn't come forward and tell us she needed one, and so there was an issue about does she specifically need to request one. Generally, yes, but sometimes it's obvious or it's very apparent that an individual may need an accommodation, and so you can't just ignore that fact. So what the United States Supreme Court said when they remanded it back down is it's possible that the employer may be liable if its decision to not hire her was motivated by the recognition that she may need an accommodation from their dress code policy. You can't rely on protected characteristics. And so we need to make sure that you all are here today to learn about this. And likely Abercrombie's corporate counsel knows very well how to handle protected characteristics and what to do with them. But sometimes employers get into trouble when they are not training their managers and supervisors that interact with individuals and make hiring and firing and disciplinary decisions so that they too know the dangers of protected characteristics. There's another photo of the gentleman on the left, and this wasn't during an interview, but it could be. He had a yarmulke, and he worked for Blockbuster, and Blockbuster said you can't wear your yarmulke because we have a no hats policy. Well, it resulted in a settlement because he continued to work without it, and then he brought a claim, and so that was, again, a situation where you should be mindful of people may need religious accommodations. And Title VII applies to employers that have 15 or more employees, but under Iowa law, or Iowa Civil Rights Act, applies to employers with 4 or more employees. So generally, employers have to provide an accommodation if it's reasonable to do so. It has to be a reasonable accommodation. And they have to do that so long as it is not an undue burden or an undue hardship to the employer. If you're a startup company or you're a small business, it's possible that the requested accommodation isn't reasonable. So let's tie this back to the job description conversation we had earlier. Maybe it's a safety-sensitive position. And so if Ms. Eloff showed up for that position, maybe a reasonable accommodation it wouldn't be something the employer could do because the job required her to wear a hard hat. And that is seen when there's safety-sensitive positions and there's certain safety precautions. Those can result in the employer not being able to provide a reasonable accommodation. So just tying that back to, again, how your job description can be important.
So finally, we get to pre-employment disability-related questions. Like I've said before, no employment or no disability-related questions should be asked before a conditional job offer has been made. So let's remember, again, back to the job application. back to the interview, back to the background check. We shouldn't be asking any of those questions prior to us making a conditional offer to that person. Now, what's a disability-related question? How do we classify that? Now, a disability-related question, it's defined as a question that would or is likely to elicit information about a disability. Still not terribly clear on what that is, but maybe some examples could help us. So some questions that may be considered disability-related, and although these may seem humorous, oversimplified, these are actual examples that we've seen in practice that are big no-nos. So how many sick days did you take at your previous job? Do you expect your leg to heal normally? Yes, an employer did ask this to someone who came in for a job. What impairments do you have? What medications are you currently taking? Do you have a history of applying for workers' compensation benefits? Kelsey addressed this earlier. Have you ever been addicted to illegal drugs? Big no-nos. So these might seem like extreme examples, but sometimes, oh yes, go ahead.
How about, do you have a VA rating? So veterans may come with a VA rating, which has some tax benefits to the business, which then gets into this gray area.
And the question, let me just repeat it, is whether you asking if there is a VA rating associated with a particular individual, if that is a disability-related question. And I don't think the answer is clear on that. It depends on the reason you're asking this question. If it ties directly to someone's disability, if information related to this person's disability could come out via you asking that question, then I would likely avoid it at this point. And there's also, unless there's a reason to ask it before a conditional offer has been made, then don't ask it at that point. Once the conditional offer has been made, you have a little bit more freedom, a little bit more rope, so to speak, to go ahead and ask those types of questions to someone. So if there's any doubt about whether a question qualifies as a disability-related question, wait to ask about it. Wait to ask until you've made a conditional offer and you've decided that this person is worth making a conditional offer to.
And to clarify, you are not a public employer? Okay, because there is some laws pertaining to public employers, and our advice today is not focusing on public employers, just to add that disclaimer.
So if you can't ask disability-related questions, what types of questions can you ask before a conditional offer has been made? Well, as we keep going back to, you should definitely ask about a candidate's qualifications, whatever relates directly to the job that this person is applying for. Make sure you're asking those questions about education, work history, any required certifications or licenses you might require. Ask about their ability to perform specific job requirements. Again, if it relates to a specific job requirement, you should be able to ask if they can perform that job requirement with or without a reasonable accommodation, without getting into the specific disability that we're talking about here. A candidate should be able to describe or demonstrate how he or she would perform specific tasks also. So if you have a question about whether someone should be able or could be able to lift a certain amount with or without a reasonable accommodation, technically prior to the conditional offer, you can ask them to demonstrate how they would do so if you do have a concern about their ability to do so. You can ask about whether a candidate can meet attendance requirements. Attendance is often very important to employers, and you can ask about whether they've had a pattern of missing Fridays or Mondays at their previous job. But I wouldn't get into reasons why they've missed those Fridays or Mondays just yet until we're talking about when a conditional offer has been made. Again, as Kelsey talked about, we have to reasonably accommodate. If someone comes in and gives you reason to believe that they may need a reasonable accommodation, we need to be asking those questions. If they can perform that job with or without a reasonable accommodation, we need to be asking that. You can also ask about what type of accommodation would be needed at that point. Again, without getting into the specifics of anyone's particular disability, you can ask what types of accommodations can be made. That allows you to go into that analysis as the employer about whether this is going to cause me an undue burden? Is this going to be overly burdensome such that I can't provide this accommodation because it's too expensive, too involved? We can't do this at our business. It allows you to kind of get into that analysis a little bit earlier.
I have a question.
Sure.
Back to the Abercrombie example that you gave. So I feel like, they didn't ask. If they had asked and then she talked about the accommodation and they still didn't hire her, is that even more, are you even more liable than if you didn't ask?
And so, yes, I understand your question, and I'm going to repeat it. Let me know if I'm repeating it incorrectly. But we're talking about the Abercrombie case that Kelsey described earlier, where they did not ask Ms. Eloff about a particular accommodation that could be made with regard to her headwear. And the question was, if we did ask her about a specific accommodation and we couldn't meet that accommodation for whatever reason, isn't that even more of an egregious situation? And so I would think that in this particular case, although the court didn't get there, we're talking about a situation where this is a requirement by Abercrombie that we, I guess, don't know the basis of. Is it safety related or is it simply aesthetic? So the court would likely take into account what do you have this policy for? And why couldn't you make an accommodation for her? So I think you're right. It does create some sort of even more egregious situation that we're talking about. In a situation like that where you don't have a truly job-related basis. Of course, Abercrombie, we all know, wants their employees to look a certain way, to look good. But that's not going to have a lot of basis, a lot of foundation in law, in permissible requirements.
Maggie, can I add to that?
Sure thing.
So we don't know all of the context of the Abercrombie example. Of course, it's always a defense from our perspective if a more qualified individual is hired. So it's possible there was only, she was the only applicant that they considered. So we don't know all of the background details of what happened, but I assure you accommodations is one of the most difficult areas for employers of all sizes to deal with. And it's also difficult because what's a reasonable accommodation for one employer may not be a reasonable accommodation for another. So this is an example where if you don't have experience, handling these types of situations, maybe just ask the traditional interview questions and then get advice from counsel about how you navigate through that as best as you can. And that's an example where the conversation with the attorney is attorney-client privileged, but if you and other mid-level managers are having conversations about protected characteristics and then you're deposed about that, that's not protected. So accommodations is really an area where we strongly encourage employers to not be the saying penny wise and pound foolish, because the exposure for these types of claims is quite large, that if you don't have experience tackling these, it might be worth a brief call with an attorney.
And just to reiterate what Kelsey said, at any stage of the hiring process, if you find yourself in a bind or unsure of what to do, call an attorney, because she's right. It is worth it to you in the long run to have that advice, have that assurance that what you're doing is the right way to do things. So we next get to pre-employment medical exam. So this kind of goes along with the disability-related questions. But there should be no pre-conditional offer medical exams done of an employee either. Physical components may be important to whatever job you are hiring for, but remember, until a conditional offer has been made, you can't require someone to submit to any sort of physical medical examination. What is a medical examination? That's also defined. It's a procedure or test that seeks information about an individual's physical or mental impairments or health. So remember, it's kind of a broad definition. It encompasses both physical and mental characteristics of someone. So you can't require any of those types of exams. What about drug testing? It's been specifically held that drug testing is not a pre-employment medical exam. So you don't have to wait until a conditional offer has been made to do drug testing necessarily. And then if you are going to do these post-conditional offer medical exams, then make your job offers conditional on that post-medical exam if necessary. Make it directly tied to that medical exam if that's important to the position for which this person is applying. And finally, the contingent offer. Here we're talking about the two-tier conditional offer. An employer cannot make a general conditional offer that is preconditioned on both the general and health reference checks at the same time. An employer has to first offer that the position is conditioned upon the non-health inquiries. And then once those are completed, if the non-health inquiries result in someone who is qualified for the position, then you can make those health inquiries. So in that two-tier conditional offer system, any medical examination should be the second tier. So just keep that in mind. So if we're talking about your conditional offer being contingent on reference checks, a drug test, and a health screen, well, you should do the reference check, the drug check, or drug test, and then the health screen should be the last thing, assuming the person has passed those two first requirements. And then the last item we're going to touch on just briefly is some drug testing. So I've alluded to this a little bit. You can drug test your prospective employees. It's not considered a health screening, and it can be conducted pre or post conditional offer. That's important to note. So you can do it at any time. Although it can be conducted at any time in the pre-employment process, what I recommend is not doing it until post conditional offer. Now, why do I say this? I don't say this because it has any basis in law. I say it because drug testing, if any of you do it, it's expensive. It's pretty pricey to do it per person. If you have 20, 30 applicants for a job, are you going to want to be spending the money up front to drug test those 20 to 30 applicants before you've whittled down the pool to who's actually qualified, who actually deserves that conditional offer? So wait until it's actually worth it to you to do some pre-employment drug testing. Wait until after that conditional offer has been made. And just a reminder, as we touched on during the interview process, you have to inform that prospective employee, I recommend in the job advertisement and at the time of the interview, that they will be drug tested prior to any employment. And then have the written policy available. Yes?
So you just said you recommend putting it in the job advertisement, but then that says you must put it in the job advertisement. What is the, do you recommend it, or what's the law?
So the law is that the particular individual must be informed at the time of the interview. And I should have been more clear on my slide. I recommend it. It's never a bad idea to put it in the job advertisement. It can only protect you more. So I would recommend that. It's not necessarily a requirement under the Iowa Code. Good question, though. And for those online, I should say that their question was, is it a requirement that the drug testing prerequisite for employment be included in the job advertisement?
So I think we're out of time. I've been kind of getting the look here. We're a little after. Maggie and I will stick around to answer any questions you have, so certainly come up and we can answer any questions.
And we also have business cards available. If you think of something at a later time, we're always happy to receive a call or an email. Feel free to do that.
Thank you.
Thank them for being here today. They do donate their time to be here, so we appreciate it. And as you can see, there's so much in depth when you get into employment. And I can say personally, a lot of you know I own Creme here in Des Moines. Davis represents us. Courtney Strutt-Todd gets a call from me every time I don't know what to do with an employee or it's questionable. So I appreciate you guys being here today. Personally, can give you a shout out. Very quickly, there's surveys on your table. If you can fill them out, it helps us make this session better every time. It's very valuable information for us, especially if there's other sessions you would like to see going forward. It would be helpful. Next week, we have an event coming up. It's the Google Holiday live stream. So we'll be live streaming here from our office with the Google headquarters. It's how to reach your customers this holiday season. It is free if you'd like to attend, or if you want us to provide lunch for you, it's $15 for that. And then the big one that's on your table as well is the summit coming up on November 10th. It's $79 for the entire entire day. We have 3 keynote speakers, 18 breakout sessions, and the breakouts are very similar to what you saw today. And then we also have 28 resource partners there as well. So if you are having an issue in any aspect of your business, there's probably a resource partner you can walk right up to and get help right there. And our premier sponsor is actually in the room. So Downing Construction stepped up and said, yes, we believe in this and want to be part of that. And so thanks to Downing Construction for doing that. And then actually Davis Brown's team, Courtney Strutt-Todd and her team will be there speaking on business law. We have SBDC there as well. So come join us. It's November 10th. It's pretty much all day, $79 for the day. Our hope is that you can get the information in one full day that you need to move forward in 2018 and really hit those goals that you want. If you like these sessions, the next one is on November 29th because we skip over Thanksgiving. And it is on how to reach your sweet spot customer. So even as our businesses evolve, our customers sometimes change. So reevaluating how to do that, or if you're getting off the ground, coaching people that not everybody's your customer is always difficult. It'll be a great session on top 5 things to identify that sweet spot customer. So thanks for being here today. Thank you again for being here and donating your time, and we'll hope to see you soon at one of the events.